Hello, you guys. How are you all? Thank you guys for being here. Hey, Princess Megan Elsa, Music City Mom. Hey, Beat Crumbs. Hey, MK. Hey, Purple. Hey, Sherry. Hey, Emily. Hey, Sue Ann. Chopper. Hey, Glowbug. Stephanie. Hey, Sexy Wild Thing Claws. Struggle is real. Leo. Hey, Annie. Maria. I'm very interested in this too. And I can't wait to talk about it with you guys. Let me finish saying hello. Thank you for being here, Emily. Hey, MK. I think I said hi to you, B Crumbs, but in case I didn't, I don't want to miss you. Chitty Chatty Meg. Hey, Mark. Hey, April. Chris, Chopper, Lily. Anybody I missed? Hey, Danielle. Hey, Web Weaver. April. Thank you guys for being here. Okay. Hey, True Crime Chucky. That's a pretty cute account. Hey, Guidance, you're here in your regular account. Hey, Corky, I'm working, so I can't chat back, but I'll say a blanket hello. Hey, Melinda. So, we've been covering Idaho since it happened, but we haven't really been talking a ton about it lately. When I saw this, it's interesting, and I'm kind of excited to see what happens. So first, I'm going to play a little video from Court TV. I think it's interesting because her opinion varies so much from a lot of what we're seeing on here. Then I'm going to show a couple little things from Twitter, and I have the documents that I want to pull up and a CNN article. So we have a few things to go through. I'm excited to look at it all with you. Let me go ahead and switch to this Court TV video. And then I'm going to read the article, and then we'll get into some of the documents because I have them pulled up too. But basically, the defense has an issue with the grand jury hearing. The burden of proof that they used, we're going to read through it all to see exactly what they say. But they're saying either throw my case out or please give us a preliminary hearing. That really is exciting for me and should be for you guys too, because if they were to do that, which I don't know if they will, but if they were to do that, then we would get, a lot more information. When they had the preliminary hearing scheduled, it was said to be like a week long. I think that they have a lot that they showed at this grand jury hearing, or they would show at this preliminary hearing. So it's exciting because we might actually get some real information about what's going on here. Hey, Punksy. Hey, Andrea. Hey, Janessa. Good to see you. Hey, Dakota. So let me play this first, and we're going to get into it all.
In the Idaho 4 murder case against defendant Bryan Kohberger. Some brand new court filings have just been released, and the most eyebrow-raising among them is a motion to dismiss the charges entirely. Kohberger's defense team is saying that the grand jury indictment needs to be dismissed, saying that those grand jurors were misled on the standard of proof that is required for an indictment, saying that the standard should be beyond a reasonable doubt. You know that standard, the one we see at trial. They're saying it's not the standard that was given to them, which is more of a probable cause-like standard, the reasonable belief that a crime was committed.
That's interesting. We've talked a lot about that because the burden of proof changes as you go along. When they're first arrested, it's basically just, is there a probability that a crime was committed by this person? And then it goes on to beyond a reasonable doubt at the trial.
By the defendant, Bryan Kohberger. The motion is 23 pages long and asks for a preliminary hearing in the alternative to an outright dismissal of the case. In the conclusion of the motion to dismiss Kohberger's defense team writes in part that the grand jury system in Idaho is, quote, tragic and unconstitutional.
Okay, that was big to me, and that's why I put it on the thumbnail. The grand jury, the defense said the system in Idaho with the grand juries is tragic and unconstitutional. Now, we knew Ann Taylor was a good lawyer. Her whole purpose is to create doubt, right? And I think that she's doing a decent job of that already.
Goes on to say that no court had the power to decide that the legislature made it too hard for grand juries to do their work and change the sufficiency of evidence required to indict. Mr. Kohberger is asking this court to recognize the long string of error that led us here and give back the people of this state the protections that they are owed. Okay. I say nice try by the Kohberger defense team, and that there's no way this is getting dismissed. Look, I wasn't there when this case was presented to the grand jury. I'm not the prosecutor on it. I don't know what standard they were given. They got the transcripts from the grand jury proceedings.
Remember, I told you her opinion is, kind of different from what we see on this platform. She says, no way, it's not going to happen. Nice try, Bryan. I'm curious what you guys think, because I'm seeing a lot of people who have a lot of doubt that Bryan is the one who committed this crime. I personally don't feel that way. Not yet. I think that we don't even have, we don't have enough evidence to say that. But
remember, we told you about the fight over that. But if they even get their wish, if they get this kicked back to the magistrate court for a preliminary hearing, do they think that's going to go well for them? Do they think that it's going to get kicked there? There's no magistrate judge on the planet who's going to get rid of this case. That's my take on it at first glance. Let me bring in my guest still with me in East Lansing, Michigan, trial attorney Jamie White, and want to welcome, standing by in the Woodlands, Texas, former DEA senior special agent.
Okay, so we're going to pause that there. I want to keep going because we have a lot to go through. So here is an article that I wanted to show you guys. So the prosecutors in Bryan Kohberger case, we're going to go through the defense paperwork, but this kind of talks about some of what they're asking for, but also the prosecution. Prosecutors in Bryan Kohberger case request court compel information on potential alibi. Prosecutors in the case of Bryan Kohberger, the man accused of killing 4 University of Idaho students in the fall, have filed a motion asking a judge to compel his defense team to share information about his potential alibi. The state's filing on Thursday, so yesterday, came days after attorneys for Kohberger suggested he was not at the location where the crimes took place. Kohberger faces 4 counts of first-degree murder. Prosecutors requested in their motion that the defense provide information on the specific place or places where Kohberger claims to have been during the time of the crimes, as well as the names and addresses of all witnesses they plan to use to establish an alibi. So someone had said, he's refusing to give an alibi. Well, the state is pressing him on that. They say, if you got one, you need to give it to us. Grand jury indictment means it is likely he did it, not beyond a reasonable doubt that he did it. That is the way I have always understood it, Amber. She is serious, Mrs. M. Hey, Tiff. Good to see you. This is like Daryl Brooks, Letitia, Taylor Shabusiness, and all trying to have their cases dismissed. Well, you're right. It frequently happens. Lori Bell, they always ask for that. I think it's basically one of the steps that they take in case there is they come back to court for any reason. You know what I mean? Okay, so let me continue to read. They say, it is important to note that the scheduled October 2nd, 2023 jury trial is barely more than 2 months away, the court filing says. If the defense intends to rely on alibi, it is essential that they be required to provide prompt notice so the state can fulfill its obligations under Idaho Code 195192 to investigate and respond to the notice of alibi. Any further delays will substantially prejudice the state's rights. Prosecutors also requested the defense be required to provide the information within 10 days of a potential court order, according to the motion. Evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules, as well as statutory requirements. Ann Taylor wrote in a document filed Monday. So she filed that Monday, and on Thursday they said, no. If you have an alibi, we want it now. Judge, please make them give it to us now. It is anticipated this evidence may be offered by way of cross-examination. This is what, Ann had said in their filing. Kohberger stands firm on his constitutional right to silence as well as to testify on his own behalf, his lawyer said. The students' killings rattled the small Idaho college town of Moscow and have been the focus of a lengthy investigation. Kohberger was arrested 7 weeks later. So then they have a little bit where they talk about the defense filing additional motions. Let me see. Okay. One request. Okay. Attorneys. I messed up. Here we go. I started one line down. Attorneys representing Kohberger filed 2 additional motions this week. One requests a stay of the proceedings, claiming prosecutors failed to comply fully with Title II of the Idaho Code, which governs requirements for convening trial juries or grand juries. So they're requesting a stay for the second time, when the prosecution has already said, if you request a stay, you are therefore giving away your right to it, waiving your right to a speedy trial, not a fair trial. Hey, Ren. Hey, the Looking Glass Tarot. A sworn affidavit filed under seal in conjunction with the motion outlines the specifics of the allegations, according to the motion, but attorneys cite selection of jurors and jury questionnaires as issues of concern. Further, other irregularity exists within the grand jury process, and further investigation is necessary to determine the impact, if any, in the convening of this grand jury, the motion says. Another motion filed at the same time on Tuesday seeks to dismiss the indictment against Kohberger, arguing, quote, the grand jury was misled as to the standard of proof required for an indictment, unquote. Defense attorneys argue the Idaho state constitution sets the standard of proof for a grand jury at beyond a reasonable doubt. But the grand jury in the case against Kohberger was given a lower standard required for an archaic process called a presentment, which requires a preliminary hearing. In turn, failing to properly instruct the grand jury is grounds for a dismissal of the indictment, the defense argues. Idaho's criminal procedure law defines a presentment as a formal statement by the grand jury indicating to the court a crime has been committed, and there are reasonable grounds that the person named in the presentment committed the crime. So that's kind of what you were talking about, Amber. The presentment, the burden of proof is there are reasonable grounds the person named committed the crime. But the defense is arguing in that it should have been beyond a reasonable doubt. So this will be interesting to see how it shakes up. I hope we get a preliminary hearing. I really do. I think that will be good. There are so many rumors and lies and bullshit spinning in this case. I mean, really, we've got a very small percentage of the evidence that they must have, especially if you remember when they had the preliminary hearing scheduled originally, it was supposed to be a week long. That is several days of witnesses and evidence against Bryan, right? That is what they were planning for. So I think that they have quite a lot more than we know. In comparison, an indictment under Idaho law is a written accusation presented by the grand jury charging a person with a public offense. His attorneys argue the indictment should either be dismissed or be treated as a presentment and have a preliminary hearing. They acknowledge in the motion that the defense recognizes that the whole of modern jurisprudence on this issue is against it. Due to a wide-ranging gag order, prosecutors, defense lawyers, and attorneys for victims' families and witnesses are prohibited from saying anything publicly aside from what is already in the public record. So, let me talk to you guys for a minute. I'm going to flip over to the defense's motions, and we're going to flip through it. But I want to hear what you guys say first. Oh, who gifted? Thank you, guys. Let's see. Oh, thank you, Carol freaking Claus. She is always so thoughtful. Very sweet. Thank you. Hey, J Lord, how many people does it take one person to turn themselves in over 2 misdemeanors, at least 6 if you're Carly Russell. Oh my God, that situation like really frustrates me. I missed the press conference and stuff. I had a lot going on here with just my family at home. And I went back to see some of it. I saw her mugshot and stuff. I wish that people would stop giving her attention. I understand people are interested and want to see her pay for what she's done. I get that. But I just don't think she deserves the attention. And no, you don't always have to have the smoking gun to convict. There will still be rumors and lies. There will be. You're right, Lacey, but I think there will be less. Doesn't even have an alibi, let alone witnesses. Hey, Cashmere. On the edge of my seat. They will never overturn the indictment. He just wants to see who saw his handiwork. Well, he's got the grand jury transcript, so they know what happened now, right? I don't believe they will overturn the indictment either. However, I think there's a possibility that they may go ahead and do a preliminary hearing because they want this to be as fair as possible. They don't want him to be able to say, I didn't get a fair trial because of X, Y, and Z. And we already know Ann Taylor, she's ready for battle, basically. Well, we were going to read through this and see exactly what she says. Jaded says, so sick of criminals trying to get away with ish. Lucia, yes, I agree. They are not telling us a lot. Hey, crazy mama. Hey, Amber. I'm a nurse. Some work days are terrible days, but when I come in Allie's chat, it makes my day so much better. This is the best group of people ever. I agree, Mrs. M. You guys are incredible, and you make my days better, too. So thank you. Hey, Headphones. Good to see you. Headphones votes. Sexy wild thing claws. That's the most amazing chatter. Hey, Butterfly Kisses. Today's live was, ooh, crazy mama. I didn't know you did one. I'll have to go check it out. And let's see, what did I put you in my Nightbot under? I don't know. I'll try that and then this too. Hey, Natasha, thank you. Amber, what do you think about this? ATS News. I see you just came in here. I'm really curious on your thoughts. Do you think there's a possibility they will do a preliminary hearing with what they're asking? Hey, Candace, I hope you're having a good day too. In my opinion, the defense is just digging. Hey, Keyboard. We love claws. Okay. I don't believe any of that paperwork even specifically comes near to even talking about Kohberger, just generalizations, really. Okay, so let's see here. Well, first, let me show you this tweet. I know a lot of people are not a fan of Coffindeffer. A lot of people are. Here's the thing. You may not agree with her opinions, but she's definitely got much more experience than most of us, right? So it's kind of like I was talking to my dad. My dad is a retired chemist. He has a degree in biochemistry and nutrition. And we were talking about vitamins. And he's like, no, you're wrong about this. I'm not going to be like, oh, I know better than you because I researched on Google. The man has a degree in it. He has retired from a job doing that his whole life. He probably knows better than me. That's kind of the way I look at, some of these, well, really all of the professionals. Even if I don't care for them, I still want to hear the opinions. So she says, in a nutshell, the prosecution is trying to compel the defense to pony up proof that Bryan was somewhere else during the murders, as they indicated in their filings concerning the alibi. I don't think they have a smidge of proof in this regard, or they would have disclosed it. We shall see what their experts come up with. That is their only hope. Standing by, Jeopardy music playing softly in the background. So let's look at the paperwork. Here we go. I'm going to exit out of some of these windows first, and then Tiff says Coffindeffer picks out stuff to fit her narrative. That's in any case. A lot of people have their thoughts on her, I like JC, but she's wrong on this. Hey, Anna. Thank you, guys. Oh, Eddie, thank you. Remember Ted Bundy and his ridiculous games? He's a retired human. He is a retired human. Yeah. And so, I'm not saying they're always right. There are some that I definitely have thought were wrong many times, but I still, think it's interesting. You are, Chopper? Oh, gosh. I'm like, my life is like a lot of big vocabulary and talking in circles that I zone out and don't listen to. I try, but okay. So let's go ahead and get started on this. So it's from Ann Taylor, Public Defender, Kootenai County. Comes now, Bryan C. Kohberger, by and through their attorney, J. Weston Logson, Chief Deputy Litigation, and hereby moves this honorable court for an order either dismissing the indictment in this matter or to treat it as a presentment and remand for a preliminary hearing before a magistrate. This motion is made on the grounds that the grand jury was misled as to the standard of proof required for an indictment. So I'll try to put myself in the mind of the judge when I'm looking at this, because I'm wondering what this judge is going to do. What are they going to decide? So here are their issues. Number one, the Idaho Constitution, Art 1, Section 8, set the standard of proof for a grand jury at beyond a reasonable doubt based on the plain language of the statute. We should read that statute, because if this is true factually, I think that they're right. I think that you have to go with the Idaho Constitution, period. The legislative history of IC 191107 also supports a beyond a reasonable doubt standard. The Idaho Supreme Court cannot adjust the standard of proof, as it is a substantive right. Their second issue is the failure to properly instruct a grand jury as to the standard of proof is grounds for dismissal of the indictment. The grand jury was erroneously instructed with the standard required for a presentment. Thus, this court could treat the indictment as a presentment. Judge will deny it. That's true, Chopper. That is true. Well, when I was talking about those vitamins, I had a lecture about metabolic pathways and all kinds of other stuff that just like I kind of zoned out. But okay, so argument 1, the Idaho Constitution, Art I, Section 8, and IC 191107 set the standard of proof for a grand jury at beyond a reasonable doubt. The grand jury ought to find an indictment when all the evidence before them, taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a grand jury. This statute was in existence at the time the Idaho Constitution was adopted. Idaho Rev Stat RS 7636, previously Criminal Practice 208, quote, when construing the Idaho Constitution, the primary object is to determine the intent of the framers. And then they have another quote, provisions of the Idaho Constitution must be construed in light of the law prior to their adoption. Even Idaho's Constitution reflects this view. All laws now in force in the territory of Idaho which are not repugnant to this Constitution shall remain in force. In Clark, our Supreme Court found a statute in force at the time our Constitution was ratified to be controlling in its interpretation of Article 1 or Article, I don't know if it's I or 1. In State versus Matthews, our court considered the issue of whether search warrants needed to be signed in order to be valid. The court found that warrants do need to be signed, or else a search pursuant to such a warrant will violate Art 1 of the Constitution. The court arrived at this conclusion despite the fact that Art 1 is completely silent regarding whether a warrant needs a signature. The reason the court was able to find a constitutional violation in this case was by acknowledging that the statutes which require a signature, quote, predate the Constitution of the state of Idaho, unquote. Because these statutes, which require a signature on warrants, predated the Idaho Constitution, they, quote, create a substantive right, unquote, which, quote, existed prior to the adoption of this state's Constitution, unquote. And then in State versus Roush, 99 Idaho 586, our Supreme Court found a defendant was entitled to constitutional relief for a violation of IC. Knock and announce, after finding the rights contained in that statute were long-standing at common law and deeply rooted in our heritage. The Rauch Court was able to trace this deeply rooted heritage all the way back to 1603. Thus, whatever this language means, it must color this court's interpretation of Art 1. And then they put, no person shall be held to answer for any felony or criminal offense of any grade, unless on presentment or indictment of a grand jury, or on information of the public prosecutor after a commitment by a magistrate, except in cases of impeachment, in cases cognizable by probate courts or by justices of the peace, and in cases arising in the militia when in actual service in time of war or public danger, provided that a grand jury may be summoned upon the order of the district court in the matter provided by law, and provided further that after a change has been ignored by a grand jury, no person shall be held to answer or for trial therefore upon information of public prosecutor. I'm not sure they even know how to define that, because they say, thus, whatever this language means, it must color this court's interpretation of Art 1. They said if it was not clear from the text of Art 1, Section 8, the framers' general intent behind the section was to ensure that either a grand jury or magistrate stood between the prosecutor and the accused. See Proceedings and Debates of the Constitutional Convention of Idaho, 1889, Volume 1. Thus, it stands to reason that the standard of proof in effect at the time of the adoption of this section was incorporated into it. It would be rather ineffective to create a buffer between the government and citizens that the government could change willy-nilly. However, that does not provide, they put willy-nilly in their motion, that could change willy-nilly. Let me check on you guys. Hey, Carol Clark. Hey, Woofy. Is Woofy in here? This is exciting. I hope we do get a preliminary hearing. Bye, MK. Okay. Willy-nilly. Let's continue. So they say the plain text of IC sets a standard of proof that would warrant a conviction at trial. The justification for a conviction at trial is and was proof beyond a reasonable doubt. If that were not enough, IC is one of the many laws that were adopted in 1863 or 64, copied verbatim from laws adopted in 1851 in California. The Idaho Supreme Court has held, this court has consistently held that a statute which is adopted from another jurisdiction will be presumed to be adopted with the prior construction placed upon it by the courts of such other jurisdiction. I don't know. I have to say, I do think they're making a good point that maybe there needs to be a preliminary trial. Am I just biased? Maybe. So in the People versus Tinder and Smith, this is another case they're referencing, in 1862, the defendants were indicted for murder and arrested. They applied for bail but were denied. On habeas petition challenging the denial of bail, the California court took time to discuss the legal standard required for the finding of an indictment. The court found, formerly, an indictment was regarded as a mere accusation, which the grand jury ought to find if probable evidence were adduced in its support. But great authorities, says Chitty, have taken a more merciful view of the subject, and considering the ignominy, the dangers of perjury, the anxiety of delay, and the misery of a prison, have argued that the grand inquest ought, as far as the evidence before them goes, to be convinced of the guilt of the defendant. What was, therefore, anciently said respecting petit treason may be applied to all other offenses, that since it is preferred in the absence of the prisoner, it ought to be supported by substantial testimonies. The more merciful view of the subject thus referred to is secured by statute in the state. Our Criminal Practice Act declares that the grand jury shall receive none but legal evidence and the best evidence in degree to the exclusion of hearsay or secondary evidence. And though not bound to hear evidence for the defendant, that is their duty to weigh all the evidence submitted to them. And when they have reason to believe that other evidence within their reach will explain away the charge, they should order such evidence to be produced. Wow, that's quite interesting. They put that in here, right? So they're quoting something from an old case, actually, I think out of California from the 1800s. But the quote says that if the grand jury, even though they don't have to listen to the defense's side. The defense doesn't present anything at a grand jury proceeding. If they have evidence within their reach that will explain away the charge, they should order such evidence to be produced. And that they ought to find an indictment when all the evidence before them taken together is such as in their judgment would, if unexplained or uncontradicted, warrant a conviction by the trial jury. And of course, ought not to find an indictment when the evidence taken together, if unexplained or uncontradicted, would not warrant such conviction. The indictment is then something more than a mere accusation based upon probable cause. It is an accusation based upon legal testimony of a direct and positive character and is the concurring judgment of at least 12 grand jurors selected to inquire into all public offenses committed or triable within their county, that upon the evidence presented to them, the defendant is guilty. What do you guys think so far? Well, if he says I didn't do it. Hey, Matt Wickett. Hey, Deco. Good to see you. Brian knows he's done, and it will get more ridiculous than this because it's the last see how smart I am. Well, I think, like I said, they're doing their job. Blah, 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 Blowburger. But they're almost convincing me only because I want him to have a fair trial. And if they can find in their Idaho code that the grand jury, if it's not a presentment, should be beyond a reasonable doubt, then I don't know. I think that we should probably do a preliminary hearing. We'll see. Let's see. Kay Bray says, I know this sounds crazy, but what if someone has an alibi, but then they don't present it until like trial or something? That makes no sense to me, though, because if you have a solid alibi that shows you are not there, why would you wait to present it? And I am interested in the fact that the prosecutors decided to go with the grand jury instead of having a preliminary hearing. At a preliminary hearing, it's basically like a mini trial. You have the prosecution that goes first and brings, in this case, several days of evidence. And then, oh no, Woofy, I didn't say, I don't even have my phone. But anyways, in the preliminary hearing, it's several days of evidence against him. His attorneys have their opportunity to battle that evidence. And yeah, I just think that it could help in many ways. In my opinion, this is all very reasonable to me. That's kind of how I feel. I hate to admit it. His girlfriend's putting money in his commissary. I know this sounds crazy. What if this confusion sets him free and then he kills again? It's very possible. Jaded, I don't know. They're only doing it once on my end. Yada, yada, yada. BK needs to be prison mates with your business. All right, let me continue. So thus, the only case on point from the time this statute was adopted clearly states the standard for finding an indictment is higher than the probable cause standard. In addition, other jurisdictions and legal treatises have recognized that the plain language amounts to more than probable cause. The defense does not, by all this, intend to bury the lead, but merely show that under the usual approach to statutory interpretation, there is no reasonable doubt as to what a grand jury should be instructed. That said, the defense recognizes that the whole of a modern jurisprudence on this issue is against it, as well as at least one founding father of this state. A legislative history of IC also supports a beyond a reasonable doubt standard. So they say the history of this formulation shows that the abandonment of the standard and the retreat to common law probable cause has no basis in law. To begin, the formulation first appears in 1850, and this is out of New York. To understand why the field code. Here, I'm not going to actually read through all of that. They're basically citing other cases and why. I will read about it, but not each individual code. So at the time of this country's founding, colonialness had knowledge of this history and experience with the power of grand juries to prevent government abuses, as well as experience with what is known as a preliminary hearing. More importantly, the colonies had experience with something that never took hold in England: local public prosecutors. While the development of the magistrate's power to dismiss felonies after a preliminary hearing in England is mostly lost, in America, a number of historical writings shed light on what was known to those that adopted the Constitution. So they're basically trying to argue that we think the Constitution means this because of this. Hey, Mallory. Yes, Jaded, I definitely know what you mean by that. For sure. These laws are outdated. It's 2023. Hey, Lou, that's a good point. There are, however, a few known expectations to English procedure. In Massachusetts, the examination procedures seem to have permitted witnesses to be questioned in the presence of the accused. The early New Haven colony departed farther from the English model than most colonies. Here, the justice, or more often the justices, were formally permitted to dismiss charges when they became convinced of the accused innocence. In Virginia County, courts initially appear to have examined arrested suspects to determine whether the accused should be tried before the general court. In 1705, a new institution, the examining court, was introduced. After a preliminary hearing before a justice of the peace, the case was sent to a special examining court, where the accused was again questioned by several justices of the peace. Here, the accused was entitled to require the sheriff to summon witnesses on his behalf. Either the accused was released or the case went to the grand jury and eventually to a trial jury. Basically, I think that he has very good attorneys, and they're doing a good job at trying to get the judge to see their side of things and see the way that they're comprehending this language. However, I agree that it's outdated, but that's kind of what they do in all of these courts, hearings, and trials. They go back to other instances where a ruling has been made in a similar situation, and they use that to kind of guide what will go on forward from there. Then they quote Barbara Shapiro in Beyond a Reasonable Doubt and Probable Cause from 1991. Then they put a link. They just put many people that have commented on this and where they can find the information. They say, in spite of their experience with the discretion of the public prosecutor and the protections afforded by preliminary hearings, it was the grand jury that the colonists looked to for protection from government abuse. For example, a grand jury refused to indict Peter Zenger for seditious libel against the royal governor of New York. Roger Fairfax, grand jury discretion and constitution, then they cite their source. The royal government would later charge him by information. After 1776, every state except New Jersey provided a right to a grand jury in its constitution, and every state adopted a statute securing the right. Thus, it is not surprising that James Madison included the grand jury clause in the Fifth Amendment, nor is it surprising that the amendment met no opposition. In fact, the amendment was so popular that Hamilton devoted a Federalist paper to arguing against it, citing essentially the same reason: the need for growth in the law, that the Supreme Court much later found convincing. in this particular case out of California, the clause prevented the federal government from making an end run around the grand jury when seeking a criminal charge. But all was not well with grand juries by 1850. They're giving us a history lesson on grand juries. So far, from reading this, what I take away is that, number one, they really put that out there about exculpatory evidence. They want Bryan, and about the defense hearing the people testify against him and hearing the evidence they have against him, and also having the opportunity to speak. Because like I said, during the grand jury, the defense is nowhere there. They can't give their side. They can't object. They can't, any of that stuff. So they said they talk about the field in 1850, the Field Commission wrote in their code, in approaching the subject of powers and duties of the grand jury, the commissioners have felt much embarrassment and have therefore devoted to it the patient and laborious consideration which it demanded. The value of this institution is at the present day variously regarded. By some, it is deemed of the highest importance, as furnishing, by reason of its secrecy, a most valuable aid in the efficient detection and punishment of crime, while by others it has been regarded, by reason of that very secrecy, as subversive of the rights and destructive of the liberty of the citizen. Wow. That's kind of interesting quote to put in there. I agree with you, Chopper. I don't think it will be dismissed either, but I think they might be able to get a preliminary hearing. I'm worried that the judge is going to read this and think, wait a minute, I want him to have the fairest chance possible, so it can't be overturned. They said, as a concluding rule on this subject, the grand jury should be distinctly informed by the law that they ought to find an indictment when all the evidence taken together is such as in their judgment would warrant a conviction by the trial jury. So they're basically saying the grand jury should have the same burden of proof as the trial jury. The attempt to save the grand jury was adopted in California. Then, as noted above, the Idaho Territory copied these laws verbatim and maintains them all to this day. That's why they're still referencing Idaho. In 1862, the California Supreme Court recognized the import of the language of the Field Code. 20 years later, in Hurtado versus California, the Supreme Court likely incorrectly ruled that the grand jury requirement in the Fifth Amendment did not apply to the states, evidently convinced that the common law way of running grand juries was not worth preserving. They said all the grand jury is entitled to do to say there is probable cause to believe the man is guilty. Let's see. We're going to scroll down a little bit because the history lesson is interesting what they put in here, but not necessarily what we want to go through. They're still in 1889. The next Idaho case to mention the distinction was in 1970. So a defendant was charged via grand jury indictment. The defendant alleged that the grand jury had received hearsay evidence in violation of IC. However, the court disposed of this argument because appellant has presented no record on appeal of what evidence was before the grand jury. Despite disposing of this argument, the court then made the following comment. IC 1911-02 only requires that the grand jury find that there is reasonable ground for believing that a particular individual named or described has committed a certain public offense. So, not reasonable doubt, beyond a reasonable doubt, the burden of proof that they're stating here is a reasonable ground for believing that they committed the crime. No further explanation or citation was given for this statement. The obvious and glaring error in this statement is that the court did not quote the standard required for finding an indictment. It quoted the statute defining the standard required for finding of a presentment. Again, no further analysis was provided by the court as to why it would be quoting the standard used for a presentment when an indictment was at issue in the case. One possible explanation is that neither party brought to the court's attention that Idaho actually has two separate statutes defining the standards for indictments versus presentments, since that question was not presented as an issue on appeal. They make a good point, I gotta say. He just wants info so he can form an alibi, Detra says. I mean, if you really have an alibi, why do you not? I don't know. I would think if you have proof that you were not there, you would be screaming and shouting it from the rooftops to get your ass out of jail. Why would you wait? Wilby, I'm just curious why she wants a prelim so bad. Thank you, Lena. Who, me, Willie? Or Ann? I want one, because I want more information. And if we get that, we'll have like a week straight of court hearings. Well, Lori Vallows was a week, or Chad Daybell's rather, because Lori was in the mental hospital. But they're from Idaho, so I kind of look to that as an example. Theirs was a week long, and they gave a lot. Like, I was so shocked at how much we found out. So when they first originally scheduled Bryan's preliminary hearing, they scheduled it for a week. So that just makes me assume that they have a week's worth of stuff to go through. I think that would help because all of the rumors and stuff, you know? He doesn't have an alibi, Detra says. The thrill of the game in his mind, Sexy Wild Thing Claus says. Okay. Finally, the distinction was again mentioned in State versus Edmondson in 1987. So this is their last example, I believe. So in this case, the defendant challenged the grand jury indictment as a violation of his equal protection rights. The court quickly disposed of this argument by stating that Edmondson's failure to request a preliminary hearing is dispositive of this case. However, the court then continued by taking a more in-depth look at the equal protection argument. While doing so, the court made following comment. The purpose of both grand jury proceedings and a preliminary hearing is to determine probable cause. No explanation or citation was given for this statement. Several pages down, the court again commented, the purpose of a grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. Again, no explanation or citation was given for this statement. Several pages after this, the court briefly discussed the issue of prosecutorial misconduct. During this discussion, and again in dicta, the court made the following comment. Just a second, you guys. Mallory, when would that be? Would that have to happen before the trial date or would it push stuff back? Well, I think that depends, right? Because number one, the prosecutors are already telling him, if you are still asking for a stay, then you have to waive your right to a fair trial. I personally believe that he's not wanting to waive his right to a fair trial because that gives the prosecution less time to be prepared and get ready. That's like, common for accused people to do when they want to keep the prosecution on their toes, basically. So I think it depends, because if they say we want a preliminary hearing, then I think the prosecution could say, well, judge, if we do that, then he has to waive his right to a speedy trial because we won't have time. And at that point, I think that it would push the trial back. But I don't know. That's just my opinion. B crumbs, it's a lot, so I don't want to keep you guys, too long. Even though I know they're never going to overturn the grand jury, and I believe 100% patient. Imagine if it happened, he'd fire those lawyers because he wants to corner and scare those two girls. Well, did I say a fair trial again, Squeaky Will? Yes, I mean, waive his right to a speedy trial. I do not know why I keep saying that. He's not going to waive his right to a fair trial. A speedy trial. Jesus. Keep me forever, Alex. Okay, legendary. Okay. Lord have mercy. Y'all know what I mean when I do not mean waive his right to a fair trial. So the court made, in reference to the last case that they've brought up from 1987, the court made the following comments. We note that and isn't it interesting that they even put this in here? This goes past grand jury. Now they're on to prosecutorial misconduct. It's like they're I don't know. It's interesting. They say, we note that the prosecutor directed the grand jury that it should not indict unless all the elements of an alleged crime are proven beyond a reasonable doubt. This is a much higher standard than is required by Idaho law. They said again, no explanation or citation was given for this comment. One feasible explanation for why the court in Edmondson was of the belief that only probable cause was required for the finding of an indictment is that by the time Edmondson was decided, Idaho had now adopted Criminal Rule 6, which provided that an indictment could be found if there was probable cause to believe the accused had committed the crime. The court did not explicitly cite this rule, but the rule was in effect at the time. Then they say this brings us to our next issue. Dun, dun, dun. That's how I feel reading it. Like, ugh. Their next issue is this: Idaho Supreme Court cannot adjust the standard of proof as it is a substantive right. Despite the fact that IC 1911-07 explicitly sets the standard of proof required for an indictment, approximately 100 years after Idaho codified the standard to be applied, our Supreme Court adopted ICR. ICR states the grand jury ought to find an indictment when there is probable cause to believe defendant committed the offense. It is therefore necessary to determine what standard governs, the statute or the criminal rule. Although a clear line of demarcation cannot always be delineated between what is substantive and what is procedural, the following general guidelines provide a useful framework for analysis. Substantive law prescribes norms for societal conduct and punishments for violation thereof. It thus creates, defines, and regulates primary rights. In contrast, practice and procedure pertain to the essentially mechanical operations of the courts by which substantive law, rights, and remedies are effectuated. The standard of proof required for the finding of an indictment is not a procedural right. The standard of proof does not concern the forms of process, writs, pleadings, and motions. It does not deal with the manner of service or time for appearance, nor is it a matter of practice and procedure in all actions and proceeding. The grand jury statutes set out the substantive rights of every citizen that must be followed before any citizen can be held to answer on a felony charge. This is a substantive right in that it grants every citizen of Idaho the right to not be held to answer on a felony charge unless the standard set out in IC 1911-02 has been met, where this only a matter of procedure. Every citizen of this state would be subject to detention to answer for a felony charge based upon the whims of the Supreme Court. Standards of proof are considered to be substantive in every context except apparently in dealing with conflict of laws. The Idaho Supreme Court has found it is a procedural issue, and the standard of the forum state applies. The United States Supreme Court, meanwhile, vehemently disagrees. In 1942, the court found that the standard of proof is part of the substance of a claim and cannot be considered a mere incident of a form of procedure. The court has followed that holding in various cases thereafter, and they cite those cases. Then they say, however, we deal here with criminal law. Counsel can find no case that permits the courts to determine the standard in a criminal matter. Most recently, the United States Supreme Court considered standards regarding defenses in a criminal action and never once indicated it was not for Congress to set the standard because it is a power belonging to the judiciary. It appears from the authorities that courts set the standard of proof by rule only in situations that are themselves creatures of procedure, like the standard to create a class in a class action, or the standard to show a past conviction is admissible under the evidentiary rules. Hold on. Okay. I have a feeling when this case is over, Ann Taylor will cover the entire history of Idaho. It's kind of interesting. Have a good evening, headphones, because like you see they go very in depth with this, right? They're pretty determined. Then they said, if that was not enough, several important constitutional provisions should be kept in mind when considering whether this standard is substantive. First, our Constitution provides that all laws now in force in the territory of Idaho shall remain in force until they be altered or repealed by the legislator. Second, the legislature shall pass all necessary laws to carry into effect the provisions of this Constitution. Finally, the right to have a grand jury make either a presentment or indictment finding prior to being held for trial is an Idaho constitutional right. These provisions have important implications in this case. First, because IC was in force at the time our Constitution was adopted, and they, quote, shall remain in force until they are altered or repealed, unquote. Not simply until the judiciary decides to alter them, but until the legislature amends or repeals these statutes. Second, because the legislature was charged with passing all laws necessary to carry into effect the provisions of our Constitution, and because the right to a grand jury presentment or indictment is most certainly a constitutional right. It necessarily follows that it is the legislature who has the authority to pass laws that will breathe life into that constitutional right. So they're saying it's not up to you. It's not up to this court to make the rules. It's up to, Congress, the Idaho state representatives. To simply say that a person has a right to a grand jury determination means very little unless we define what a grand jury determination even means. If our Constitution simply provided for the right to a grand jury, but no law set out what that meant or what findings were necessary, the right conferred in Art 1 would be meaningless. This is why Art 11 leaves it to the legislature to pass laws defining what is meant by this constitutional right. It is not the judiciary that is given the power to carry into effect our constitutional right. It is the legislator. She's basically saying, you're not given the power to change our rights. Only the people that are, elected to represent in the state, of Idaho Constitution. Betty Jo, my opinion, the grand jury does not have to give reasonable doubt. They just have to indict, and it gets carried over to trial where the prosecution has to prove reasonable doubt. That's the way I have always understood it, is that the grand jury, the burden of proof is not the same as at a jury trial. It's basically a step past, why is my probable cause? My brain short circuit for a second. But I think that she makes they make good arguments. It was actually not Ann Taylor who did this. They make good arguments. So it's like a mini trial where the prosecution and defense, yes. Chad Daybell's was mind-blowing, the amount of information we got. I mean, they had FBI up there describing when they found, the kids. They had them describing what was in their phones. They had Lori Vallow's best friend was one of the witnesses called in the preliminary hearing. So it could get very interesting. It's a good argument, an argument they're not going to win. I definitely don't think it's going to be thrown out, but we shall see. So then they say, third, because the right to a grand jury is preserved in our Constitution. And at the time our Constitution was adopted, 1107 defined what these rights meant. Let's see. 2, the failure to properly instruct a grand jury as to the standard of proof is grounds for dismissal. They say, having shown that the jury was provided with the wrong standard of proof, the next question is, what is the remedy? The Field Code adopted a somewhat complex interplay of statutes permitting a defendant to challenge an indictment that Idaho maintains for the most part. Grounds for setting aside indictment. The indictment must be set aside by the court in which the defendant is arraigned upon his motion in either of the following cases. 1, when it is not found, endorsed, and presented as prescribed in this code. 2, when the names of the witnesses examined before the grand jury or whose depositions may have been read before them are not inserted at the foot of the indictment or endorsed. Ooh. That's interesting. So basically, if the witnesses' depositions, if their information is not inserted at the foot of the indictment must be set aside or thrown out. Number 3, when a person is permitted to be present during the session of the grand jury and when the charge embraced in the indictment is under consideration, except as provided in Chapter 11 of this title. Number 4, when the defendant has not been held to answer before the finding of the indictment on any ground which would have been good ground for challenge either to the panel or to any individual grand juror. And IC 19-2408 provides a pertinent part. A motion in arrest of judgment is an application on the part of the defendant that no judgment be rendered on a plea or verdict of guilty, or on a verdict against the defendant on a plea of a former conviction or acquittal. It may be founded on any of the defects in the indictment that are grounds of demur, unless the objection to the indictment has been waived by a failure to demur and must be made before or at the time the defendant is called for judgment. Neither of these statutes were intended to create a mechanism for challenging the instructions given to the jury. They talk about a court of appeals in New York that found that showing an instruction was prejudicial and may require an indictment to be quashed. Idaho's Supreme Court had adopted this holding, and they cite that case. So what prejudice results from telling a jury the wrong standard? Typically, courts give the jury a standard, and it is expected to follow it, even where attorneys may misstate that standard in their arguments. Unfortunately, that did not happen here. Where a jury has been misled as to the standard to the defendant's detriment, courts find fundamental error because the error goes to the foundation of the case and takes away an essential right. See State versus Erickson. Because the grand jury in this matter was only informed of the improper standard, it was a fundamental error. They're basically saying, since you told the jury that it was probable cause was the standard, or, something like that, it should all be thrown out. Boy, they must really have some damning evidence against Kohberger. Ann Taylor is doing her best to get this case dismissed on a technicality. Reeks of desperation. Oh, I think that it definitely shows that they are trying everything. They're going, to do everything. The victims didn't have a choice. There you go, El John Doe. Hey, Julia. Just like BK, want to build is all about with questioning of witnesses at his trial. He thinks he could get away with certain things. BK, in my opinion, did this when he got caught. I want to, let me finish this, because before we go, I want to pull up like TikTok and search the latest and see like people's opinions on this. Because this is like the first, there's paperwork all the time coming out in this case. But this really like sparked my interest, because I would like to see the preliminary hearing. Because the grand jury in this matter was only informed of the improper standard, it was a fundamental error, necessarily depriving Mr. Kohberger of an essential right. Fundamental error necessitates reversal, or in this case, dismissal of the indictment. And then they put A, the grand jury was erroneously instructed with a standard required for a presentment. Thus, this court should treat the indictment as a presentment. Then they say there is one final wrinkle in this error that is worth considering. As mentioned above, there is in Idaho a thing called a presentment. It does not appear from the authorities in Idaho that this thing is well understood. However, in the words of one justice, it is the only sort of accusation any grand jury in Idaho has ever produced. For the information of the court and the bar, a presentment is what our United States Supreme Court would call a term of art. Thus, although it never receives definition in the code, it has a definition that comes to us from the field code. So this is their definition they give of a presentment. The commissioners have proposed two modes of proceeding upon the action of the grand jury. First, that where the defendant has been held to answer the charge and in no other case, the jury may, if they believe him guilty, find an indictment against him. Second, that if upon investigation of a charge against him, whether originated by themselves or presented by another, they believe he is guilty of a public offense, they must proceed by presentment. The presentment is an informal statement by the grand jury, representing that a public offense has been committed, which is triable within the county, and there is reasonable ground for believing the defendant has committed it. Upon the former, he is, of course, to be held for trial, but upon the latter, he is only to be held for examination before a magistrate, in the same manner as if an information had been given to the magistrate in the first instance. These provisions, though new in practice, are in principle no innovations. In criminal code recently adopted in Virginia, a similar provision is contained, and it may be safely asserted that the principle contained in them is in consonance with the common law itself. In a late case in Pennsylvania, the office of a grand jury was stated by Judge King to be confined to the examination of such cases as were presented by the Attorney General after previous binding over by a committing magistrate. This doctrine was held in a case where a communication had been received from the grand jury stating that charges had been made by one of their numbers to the effect that one or more members of a public trust had been guilty of converting to their own use of public money and asking that witnesses should be furnished to them to enable them to examine the charge. I'm almost done reading this, but I want to read it all for people who just listen and don't look. I'm going to link this as well so that you guys can go check it out for yourself. The spirit of the rule is embodied and carried out in the provisions proposed by the commissioners, continuing in the grand jury all their powers in respect to the investigation of charges of crime. It is proposed to guard against hasty and ill-advised accusations by giving to the defendant, upon presentment by the grand jury, the same opportunity of answering or explaining the charge, as if he had been proceeded against by an information before a magistrate. While on the other hand, he is to be committed or bailed upon the presentment in precisely the same manner as upon an indictment. Basically, that he deserves the right to answer for himself and give his side, and that this grand jury proceeding should be a presentment. Note, the presentment originates within the grand jury, requires a lower standard of proof, and requires a preliminary hearing because of it. So they say, pursuant to IC 19-1207, a magistrate is to proceed on a presentment as if it were an information. At first glance, this likely appears to undo much of what has come before. After all, a presentment is an information, then it already has had a preliminary hearing. However, history being what it is, things are not so simple. In 1887, when the revised statutes were adopted, an information was the same as a complaint. Once arrested on an information, a defendant had a preliminary hearing referred to at that time as an examination. It was not until the code was revised in 1969 that the terms became truly separate. Additionally, even in 1887, the word complaint was solely used in the code when discussing misdemeanors, while an information or complaint referred to a felony, at least in magistrate court. So if your crime is just a misdemeanor, that's one thing. But if you're being accused of something so serious, then you should have the right to give your side. And that even if a grand jury thinks that you should go to trial, you should have a preliminary hearing. That's what they're saying. The question becomes, did the legislator change Chapter 5 and leave Chapter 12 alone to purposely turn a presentment into an indictment? The answer is clearly no. Although the purpose of the individual bill seems lost to posterity, in 1966 court modernization plan and the 1969 court reforms are still extant. Let's see. Conclusion. Let's read this and then we're going to go see what other people think, hear from you guys, and that is that. This was a lot of reading. Excuse me. Let me check on you guys. Is there a possibility that the case against him can be dismissed? Well, that's what they're asking. They're saying you didn't follow the rules correctly, therefore it should be dismissed. But she's good and also has a strong team behind her. I'm sure she throws the balls and says, get it. I'd offer my throat to the wolf with red roses. This case made me put glass all over my windows in case someone tries to come in. That's a possibility in any case, but it depends on the reason. It's not super common, but it's not uncommon. I agree. Almost every case that we followed, they ask for it to be thrown out before the trial and even during the trial. This is a matter that case legal experts will research and present arguments based on all kinds of antique court decisions, but that is case law. Barry Morphew, outrage times 1,000. Oh, crime curious. Oh, I'm being good, I promise. I just saw something the other day about Barry Morphew, and the prosecutors are still saying they believe they know where Suzanne is, but they can't get to her. That is so beyond frustrating. Okay, let me read the conclusion because I'm sure that it'll be kind of interesting looking over on TikTok. So, over 150 years ago, Idaho joined the state of California in adopting the Field Code, thereby adopting reforms to the grand jury system intended to restore to that system its function as a bulwark for freedom. The strange history that follows in this state, just as every other state with the same statutory scheme, is both tragic and unconstitutional. No court had the power to decide that the legislature had made it too hard for grand juries to do their work and change the sufficiency of evidence required to indict. Mr. Kohberger is asking this court to recognize the long string of error that led us here and give back the people of this state the protections they are owed. The indictment in this matter should be dismissed or remanded for a preliminary hearing. So, on July 24th, signed Ann Taylor. I don't know, you guys. I cannot wait to see what the judge says because she does his team is doing a good job at presenting, their side, their argument. I don't know. We'll see. Okay, let me get some TikTok going for us so I can kick back and just hang out with you guys for a minute. In my opinion, the state has one shot at this. I trust them. I agree, Emily. They better get it right because let me tell you, eyes are all over them and people are going to pick apart every single thing. So it will be interesting, Corey. Chopper, I want a law degree now. Right, Jaded. It's her job and she is good at it. Yes, Woofy is very sweet. She's all heart. She tries to be tough, but it's an act. No, I'm kidding. Okay, so there are some new TikToks with TikTok, when you search it, it'll show you. I need to check my stuff. I never check I'm bad about checking stuff, but it'll show usually the most recent things, and that's what I want us to look at. So
Idaho quadruple murder suspect Bryan Kohberger is ordered to reveal alibi before October trial or forfeit right to use one in his defense, as his lawyers seek to have the case thrown out. Attorneys for Bryan Kohberger, the man accused of killing 4 Idaho college students last year, are trying to get his indictment dismissed. In a new court filing from July 25th, but released on Thursday, Kohberger's lawyers argue that the grand jury should have been instructed that the standard of proof based on what was presented to them is beyond a reasonable doubt. But they weren't given that instruction, his lawyers argue. Instead, the filing claims that they were given the standard of proof required for a presentment, which the filing claims as having a reasonable ground.
how do they fit everything we just read in the last freaking hour into a 56-second video?
That a particular individual has committed a certain offense. And because the grand jury was allegedly told they could indict on a lower standard of proof, Kohberger's lawyers want the indictment dismissed. If the judge won't dismiss the indictment, Kohberger's attorneys are asking for a new preliminary hearing to argue this in front of a magistrate to decide if the case should proceed.
Very
Idaho
interesting.
quadruple
Let's
murder
look at a couple of the comments. You guys know I love to do that. Even if it was granted and is dismissed, the prosecution will just do another grand jury or preliminary trial. Someone says, I really wonder what could happen for this grand jury instruction issue. I believe they will pull that all the way to the Supreme Court. And the creator says they do this so we can't know what was used to gain how low the threshold was. Smart play from Anne on the public scale, but shouldn't be an issue. Someone said, absolute bollocks. They didn't follow grand jury rules from 1900s when it was written. Can be thrown out due to technicality? Surely not. Someone said, should we be worried? Imagine if all the disinformation on TikTok or on YouTube, girl or boy, gets him off. I like how you stick to the facts, Aaron. That's been my issue. There has been like this case. It's just, oh my God. It has evolved into such a mess. Like, yeah. Okay, next video. I need to go outside and have a cigarette with y'all.
Breaking news, Bryan Kohberger has filed an order to dismiss his indictment. As you can see here, he filed a motion to dismiss indictment on grounds of error in grand jury instruction, or in the alternative, remand for preliminary hearing. In the motion, it says, quote, this motion is made on grounds that the grand jury was misled as to the standard of proof required for an indictment. I'll keep you guys
okay. I think we got that.
updated. What do you think?
To the next one.
Drop.
What the fuck is this? What the fuck is this?
Oh, it has his release date. Of course, there's a conspiracy. Hold on. Have a good day, Roz. He's not going to present an alibi in 1,000 years. Oh, Claus, I just love your personality. You always make me smile reading the chat. Yeah, intense for sure. This is a serious misstep by court, but who knows the remedy? This is going to be very interesting to see what happens. I don't know, man.
Bryan Kohberger and his team.
The lawyer you know. Okay, let's listen to him.
Have filed a motion to dismiss the grand jury indictment, and it's based around 2 main arguments. First, the prosecutor instructed the grand jury on the wrong burden of proof for a grand jury, and second, that this should be considered a presentment, not an indictment. So issue 1 is that they presented probable cause as the burden of proof to the grand jury, and Kohberger's team argues that that is in fact incorrect, and instead it should be beyond a reasonable doubt. Now, if you're wondering where the prosecutors got probable cause, it is from the law in Idaho in their code that says probable cause is the burden of proof in a grand jury proceeding. But Kohberger's team goes back to Old English law and
wow. Okay. See, I like the way he's breaking it down. He has a YouTube channel too. You guys need to go check it out. I was a member of his channel, but he picked Sarah Boone over Taylor Schabusiness, so he gets a thumbs down. TikTok lawyers make me happy. Well, he's at least explaining to us. So it is written in their code that the grand jury burden of proof is not beyond a reasonable doubt, the modern code. However, in the Old English code, with Old English law, don't see how state can risk overturned verdict on appeal. Okay. Wolfie, will you do me a huge favor and grab the YouTube channel for the lawyer you know? Please.
And argues that under the original statutes, this should be the same burden of proof that is given to a criminal trial jury, which in fact would be beyond a reasonable doubt. He makes some arguments that are interesting, and I would say new arguments that haven't been made in quite some time, but ultimately arguments I think will fail. The second issue, which is that this is a presentment and not an indictment, is a bit of a semantics argument. Calling something that some people think are the same thing two different names can be confusing in the law, and usually we like to clear that up. But Kohberger argues that a presentment would then create a situation where the case would go before a magistrate and a preliminary hearing would happen. Therefore, because they gave the lower burden of proof of probable cause and not beyond a reasonable doubt, this is a presentment and not an indictment, and therefore the next step should be a preliminary hearing before a magistrate, which would continue out the speedy trial window for Kohberger to prepare and try this case. I don't think either of these are going to be successful, but let me know what you think in the comments.
He doesn't think either will be successful. He says the presentment argument is an argument of semantics, which I don't like that. That feels like trickery, right? Hey, Jenny. Are you leaving, Punksy? Good night. Let me put Punksy's link in here. Nay. Oh, Mal was in here. I'm dropping all kinds of amazing channels. So if you haven't checked them out, please go check them out. Ann Taylor is mixing up a word salad in her motions. I hope she plans on serving up a big juicy steak with it to the judge. I wonder how the judge is going to take this. Will he try to be on the safe side? Or is he going to say, no bullshit, you're trying manipulation, semantics, and, confusion? Oh, you're welcome, Mallory. I would have to agree because I don't know why anyone would assume a probable cause hearing would have produced a different result. Let's see if we can find anything else on it. So they're talking about how he says he's not at the location. Evidence of Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules. Then they talk about the grand jury stuff. I like for us to go through and look at other people's opinions, because even though we just read through all the things ourselves, I'm not a lawyer. I don't have a clue about some of that stuff. I tell you guys all the time, I'm just a regular mom who likes true crime. That's, Ann Taylor still has pushed the state to deal with motions and not the trial, which may have been her goal all along. But I feel like the prosecution has argued the fact that, hey, if you keep this up, you keep asking for stays, you have to waive your right to a speedy trial, not a fair trial. I did it right that time. Oh my gosh, Jenny, I just saw it and I cannot remember the exact date. I'm not going to play this one. Human remains found on a shore.
We had no indication he was here at all. We had no indication he had any interaction with law enforcement at all.
After news broke of his arrest,
this is an older video from March.
Breaking news from Moscow, Idaho.
Ooh, we're going to listen to this before we go, because Mark Garagos, another attorney, is going to discuss his take on these documents. And he's a defense attorney. So he usually takes the side of standing up for the defense or giving that perspective. So let's listen.
document dump in the Idaho student murders case. This one, like so many others, it came as a bit of surprise. A lot of documents tonight, quite a few. I got to shout out to my friend Anna, who always alerts me, my lawyer friend, when these documents come down and then helps me explain them to me, because this one tonight was quite complex. Bryan Kohberger's defense team now asking the judge to throw out Kohberger's indictment that was handed up in May by a grand jury. Kohberger's argument is the grand jury was misled as to the standard of proof needed to bring charges. Here to help us navigate this breaking news tonight, criminal defense attorney Mark Garagos. We couldn't have anyone better on than you, Mark. This is amazing to have you tonight. First of all, what does this mean?
Mark Garagos, we've talked about him quite a lot over here in reference to other situations.
Bryan Kohberger's defense never wanted a grand jury involved in the first place. Now saying the grand jury process was done all wrong. Do they have a point here?
Yeah, well, yes. I didn't talk to you about it, but I talked to your better half, Ashley. The idea that they went to a grand jury, I think, took the defense by surprise. You'll remember all the skirmishing about one of the witnesses that was out of state that they wanted to have compelled to the preliminary hearing.
Yes, I remember. And it was not Dylan. It was interesting because Ann Taylor really wanted Bethany to be there in person at the preliminary hearing. Like I told you guys with Lori Vallow, her best friend was one of the witnesses they called, and her best friend's boyfriend at the time. So if they do have a preliminary hearing, or if they would have, then I wouldn't be surprised to see some of those people there.
And they ended up compromising on that and saying they do what was called a deposition in a criminal case, which is not common practice. Here, what they're saying is, look, we not only were not told or given enough advance notice of the fact that they're going to the grand jury, but the standard, meaning the instructions that were read to the grand jury, were wrong. And what do you mean by that? There are jury instructions that tell you what the standard of proof are or is. In a grand jury or a preliminary hearing, that is what's called a probable cause proceeding. That means, I sometimes joke.
Wait a minute. So he just completely argued against what they said. He said a grand jury is for probable cause. Let me get Squeaky Will's comment. These kinds of motions are actually pretty common, but due to the gag order and lack of information in this case, every breadcrumb is a loaf of bread. The judge will simply deny the motion. And you're right about that. And that is what I think has been quite frustrating following this case, is because I try not to blow up little things. I think that the water is already so murky. There's so much misinformation. The gag order really, I don't think has helped that much. I kind of think it's fanned the flames of the misinformation, you know? Ooh, okay, Sue Ann, thank you. I'll have to check him out. Hey, Brandy. Thank you, Wolfie. Okay.
My client is breathing, but the legal definition is there a substantial amount of proof of the crime? Obviously there is, and that it ties to the defendant or the accused. Here they're saying that the standard as it was read to the grand jury, and mind you, they've got a court reporter in there that is transcribing everything, and they make the point that the grand jury was misled.
And now, they've got all the transcripts now. We saw that kind of take place within the last few weeks.
That would not necessarily throw out the case. What they're saying is, okay, the grand jury indictment is flawed. Now let's go back and have what we always bargained for, so to speak, which is a preliminary hearing where we get to cross-examine witnesses, something you don't get to do in a grand jury indictment.
So we thought there was going to be a preliminary hearing initially. Then there was the secret grand jury, and we found out no preliminary hearing. I mean, do you think there's a good chance we could end up actually having a preliminary hearing after all?
I'm always dubious or cynical about the idea of a judge throwing out a grand jury indictment. It's not commonplace, and especially in a high-profile case like this, but I've seen it happen. I can give you some high-profile examples.
Wow, okay. So not common, but he's seen it happen. That is crazy. Oh, thank you, Sue Ann. You're doing great as well. He is super unbiased, but this pushes him over the edge. Ooh, I can't wait to watch. Also, you guys remember that Dr. G who does the body language analysis? He went over some of Shabusiness's stuff. I think that would be kind of interesting to look at. Tess, I believe, is who showed that to me. Let me know if you guys would be interested in watching that or like reviewing that, because I'm interested in it.
When it has happened, I think they do have, the defense has got a compelling point, meaning they said we were led to believe that they were going to do a preliminary hearing. Based on that, we waived our right to a speedy trial, aka preliminary hearing. We relied on it as a contract. Basically, when you waive your right to a speedy preliminary hearing, you're relying on the fact that you're going to get a preliminary hearing. To then have the prosecutor go behind your back, basically, do a secret grand jury indictment, that would mislead.
Okay, so remember, when he was first arrested, he had the decision to make if he has a preliminary hearing within 10 days. That is a right that you have when you're arrested. If you want them to do it quick, they have to do it within 10 days, I believe. He waived that right. So that's what Mark Garagos is talking about. So he is saying, he waived his right to the speedy preliminary hearing. He obviously was thinking that he was going to have a preliminary hearing.
So if they can show that clearly there's a substantive difference in what the law was that was read to the grand jurors in secret, and they've got the transcript, then a judge has got a real problem. Does he want to force them to go to trial based on an infirm indictment, or is he better off just giving the defense what they want, or she giving what they want, a preliminary hearing?
What do you make of this defense team, Mark, based on the filings that you've read, from what you've seen? Obviously, you would know way more than me, but just as a non-lawyer, I mean, they seem pretty slick to me with a lot of these filings.
I always resent when somebody calls a defense lawyer slick.
So,
I mean, I have to agree, though. They do. It seems like I have to agree. Reading them, it is, well, semantics. The chances of having an indictment by a grand jury indictment are often slim. Don't expect much from this maneuvering by the defense. Body language is interesting. Everyone still think all is going ahead for the 2nd of October. It depends. If the judge was to grant their, motion for a preliminary hearing, no, I don't believe it'll happen by October. I believe that they will have to agree to waive their right to the speedy trial. However, I don't think they want to do that. I think they're keeping that in their back pocket, in my opinion, but I don't know.
All right. My dad's a defense lawyer, by the way, so take it with love.
I know who your father is, so I don't take it personally.
Okay.
I'm just telling you, I think that this team is very skilled in capital defense. I mean, there are a lot of defense lawyers who are very good, but never do a capital case. Capital cases require a constant.
Thank you.
Breaking news from Moscow, Idaho. Another document dump in the Idaho.
All right, you guys. I think we're done. Let me just do I'm gonna just see what's next. I have that.
New details could be coming about where accused
FOMO.
killer Bryan Kohberger was when 4 University of Idaho students were viciously stabbed to death in their off-campus home last November. A judge has entered a not guilty plea on his behalf. And
when
now
we started, I told you guys, the defense put in these motions, about the grand jury indictment, and then the prosecution is the last one to file motions, and this is where they are demanding that if he has an alibi, to give it now, basically. But let this play, and then I will let you guys
between prosecutors and his defense team over his alibi, which has not yet been revealed in court. The Kohberger's attorney suggests they will present evidence he was elsewhere at the time of those killings. News Nation legal contributor Jesse Weber joins me live. Jesse, thank you for being with us. So we know prosecutors have filed a motion compelling the defense to present Kohberger's alibi. Why has that not come yet?
You have to ask me. It seems like Bryan Kohberger told his defense team, hey, I wasn't there, maybe gave them an alibi. They just don't have anything to back it up at this point. And you know what's so interesting about that? If you look at the Idaho rules, by law, they had to provide the defense not only a notice that they're going to go forward with the alibi defense, but they had to say where Bryan Kohberger was, time, place.
That is so interesting. So,
and any witnesses to back that up. And they didn't supply that. They said, look, we're filing a notice of an alibi. We'll look at the witnesses that are called by the state. We'll prove the alibi by questioning those experts, by questioning those witnesses. But I feel like they need to prove more. And so when the prosecution is holding their feet to the fire and saying you can't just say you have an alibi without showing it, they may have a point.
So, Jesse, when are we?
I didn't realize that this was part of their law, that they have to give it. It's going to be interesting to see how this shakes out
this
too.
alibi. Will this not happen until this trial actually begins?
There's a strong chance we might not see it until right before the trial or at the trial. I have to imagine that if they get the defense gets some really strong witnesses to prove where Bryan Kohberger was that night at that time, the judge will most likely allow it in. Or we may see a possibility that the defense cross-examines the state's witnesses to say he wasn't there. You may claim Bryan Kohberger was there, but he wasn't. And there's
That is what they said they were going to do. They were going to show alibi by, cross-examining some of the state's witnesses and things like that. I don't think that's the same as providing an alibi. By cross-examining witnesses and, like what he's kind of saying, that we didn't see you, so I wasn't there type of thing. They are digging to see what and who witnesses have. Well, I'm done with our videos. Wolfie wants to see Banfield, so let me do a search really fast. But before we go to that, what do you guys think? Like, what is your thought process on how they wanted Bethany, rather than Dylan, to come to that preliminary hearing or come do an interview with the defense? That still is so odd to me. I don't know. I don't know what to think of it. I'm very interested to see what she has or what she has to say. And I do believe that that's why they did the grand jury, was to protect Dylan, Bethany, the families, their case, everything. I think all of those things played a part. I can't find any new ones on Banfield. I'm sorry, Wolfie. Very interesting. Yeah, my favorite word. Ellen loves Spain. They're not going to come with any alibi. It's impossible to have an alibi if you committed the crime. I agree. I personally lean to the side that they have a lot more evidence than we know about. I think it's really interesting, though, the way public perception is with this case. Many people believe they don't have enough. I mean, number one, I have to say, though, I think that a lot of people that think that maybe aren't used to following cases in live time as they're coming out, because they never give the information they have right now. That's just the truth. I think he wants to traumatize them more. Wow, I think Dylan's statement may have been a little coerced. I think he wants to mess with the witnesses. Anything old or new, as long as she's in beige. Well, yeah, because you don't want to lose valuable time looking for the real killer if this guy was really sitting in a Waffle House on security camera 45 minutes away. I agree. Thank you, Jay Kismet. That's a lot of wasted time and resources and leaving the public open to further threat. Maybe she saw something or heard something that hasn't been told. alias and alibi have the same Latin origin. Ooh, that's interesting. Oh, my word. I'm sorry. That one throws me about Bethany. I know, me too. It really does. And then, people there are so many theories and stuff, and I try to not like play into it in my mind, but I can't help it with some of them, especially when we see the screen on the floor, and just I wonder what was happening that morning between the girls. I think that's why people are so interested and can't stop talking about it, because there are so many unanswered questions. Not only that, it's a crime that rocked the whole world, right? It was very vicious, and 4 young, beautiful college kids. But to be fair, like these massive tragedies, like think about what happened out in Oklahoma, Henrietta. I mean, I don't know. It's a shame that certain cases get a lot of attention and certain ones don't. I just threw my vape. In my opinion, he chose Bethany because she was the more passive of the two. She looks like she's scared of her own shadow. Imagine how they would try and manipulate her into saying things about her roommates. Claws. Oh, thank you, Woofy. All right, you guys. I'm going to... Wait a minute. Hold on. I forgot. I can't let you guys go yet. We're going to end with this.
Whenever you're laying down somebody of my size, your head's touching one side of the wall and your feet are basically touching the bars. It's very short. It's very short in there. If you sleep with your head by the toilet, it smells foul. It's horrible. You sleep with your head on the other side, all you get is bright lights. So, I mean, it's uncomfortable in there, to say the least.
And then I think there's one description you also said that if you decided to sleep, and we've got a diet.
Oh, wow. Look, so their head is like directly beside the toilet. Well, there you go, Bryan. That's the life you deserve, buddy. No, if you did this, let me say that. Jenny says, but they mentioned things Dylan said, nothing about Bethany said. Maybe she lawyered up straight away. Jenny, I think that they did that intentionally. I think there's many things that they probably didn't mention. Like, I even think back to that footprint. It's very possible they found multiple and they haven't mentioned it. It's very possible there are lots of other things that they found that we just don't know about yet, So just because they didn't mention Bethany doesn't mean they didn't talk to her and get some valuable information. Maybe it was so valuable that prosecutors thought, we will save this for trial. We're not going to put it out in the affidavit. All right, you guys, I'm going to let you go. I'll let this play out for a minute before I go, but I'm going to say bye now. I'm going to go eat dinner. Thank you guys for being here. I hope that you have a good night. And we'll be back tomorrow on something different. We're going to continue to follow Idaho as information comes out, especially when a decision is made. Just stay tuned, and maybe I'll do a community post or whatever, but I definitely will let you guys know what happens, because I am on the edge of my seat looking forward to it. Hey, Dorothy. I think a lot will come out that may surprise us. Me too. Dylan and Bethany are the most valuable witnesses the prosecution has, so I would definitely also keep them away from everything in all media or defense. You can't risk it. I think you're right, Alan. All right. I love and appreciate you guys. I hope you have a good night, and I'll see you tomorrow. Thank you for being here. Bye.